Welcome to Divorce at Altitude, a podcast on Colorado family law. I'm Ryan Kalamaya. Each week, along with my business partner and co host, Amy Goscha, or an expert, we discuss a particular topic related to divorce or co parenting in Colorado. In addition, we have created a short series of lessons that will take you through the legal process of divorce and answer your questions, from simple to complex. Divorce isn't easy. The end of a marriage, especially when children are involved, brings a great deal of loss and change. We hope these practical tips and insights will help you on your journey to a new and better life. Now, I talked about at the very beginning of the case what the legal documents were that were necessary to file a divorce. That's the case information and sheet in the petition. Well, what happens if you resolve and settle some or part of your divorce? That is going to take the place or in the form of either a parenting plan or a separation agreement. If you settle all issues in your divorce, then you would, if you have children, then the parenting issues would be laid out in a parenting plan. The parenting plan is going to say whether or not you agree on joint or sole decision making. It's going to lay out the schedule for the parenting time and including holidays. And it will provide for who pays what in child support or health insurance. And again, you can agree to parts of a parenting plan, and judges, if you go to permanent orders, will oftentimes enter in a parenting plan, or sometimes they'll just lay out what exactly the schedule is. It's going to depend on the judge. But the thing that you should understand is that the parenting plan can be modified, and we'll get into post decree issues at a later date. But the parenting issues are going to be resolved in the parenting plan. The finances are going to be addressed in a separation agreement. So all Colorado divorces are going to have some sort of property division, and there's going to be a consideration for maintenance and attorney's fees. In a separation agreement, that is if you settle those issues, and it could be some part. So you could agree that someone's going to get the house, but then not agree on the remaining financial issues in your divorce, or it can entail everything. And there's a judicial form. Most divorce attorneys will have a template that they use for both the parenting plan as well as the separation agreement, and it will lay out to the judge in detail. And it's important that those issues are all considered: taxes, property division, maintenance, all of those things. And you would file those. And if you reached a full comprehensive agreement on all issues, then if you have two attorneys involved, you can file what's called an affidavit of decree without appearance. So that means you don't have to show up to any sort of contested hearing. If one party is underrepresented, then you can you can schedule a non-contested hearing. The court is going to ensure that the separation agreement is fair and not unconscionable, and then also ensure that the parenting plan is in the best interests of the children. Now, you need to understand that the court has an independent duty to make sure that the separation agreement is fair and not unconscionable. And the way that the court does that is by reviewing this applicable sworn financial statements, and then also has an independent duty to make sure that the parenting plan is in the best interests of the children. So that's the final settlement documents. And then ultimately, there is a decree that is entered and the decree will incorporate the separation agreement if one is filed, or if there's final orders, then that will be incorporated into the decree. And then the same thing with the parenting plan. The decree will lay out whether or not one party is having their name restored, and oftentimes will lay out what's called a support order if child support or maintenance is ordered. Those are the final documents that are needed in any Colorado divorce if you settle part of your divorce. And if you have to go to permanent orders, then that means that some issue is remains outstanding. And again, you can get into kind of details such as the decree being entered before, which is something that you're going to have to need to talk with a lawyer about. Thanks for listening or watching this short lesson on the Divorce at Altitude podcast. If you found this helpful, please leave a review or share with a friend. It does help for others that are going through or thinking about a divorce in Colorado. If you want to find out more information, please visit kalamaya.law or divorceataltitude.com, and that's KALAMAYA.law. Remember, this is educational information. It's not intended to be legal advice. Please consult with an attorney about the particulars of your case. We're happy to answer questions. Feel free to give us a call at 970-315-2365.